Alright everyone, welcome to the video lecture on Chapter 12. So this is Chapter 12. We're covering it week 4 because we're doing things a little bit out of order. In part because the 8th Amendment is going to play a big part in your final paper that you have to write for this writing emphasis class. So we're going to talk about it earlier in this semester. So the 8th Amendment has 3 rights that it protects. It protects against excessive bail, excessive fines, and cruel and unusual punishment. Now, excessive fines actually just got incorporated to the states into 2019 in a case called Timms v. Indiana. So we have, this is actually pretty new and it came from our area. Excessive bail has been litigated a fair amount. This generally means that the amount of bail set should be enough to ensure the defendant comes back, but no more than that. And bail is not intended to be punitive. It's not a punishment. But the bulk of the 8th Amendment, as far as the jurisprudence and the cases go, that's what I mean when I say jurisprudence, the cases go, is on the death penalty. There's a lot there. So, and that's part of what your paper is going to be about. Just really quick running through what bail is. Bail is money or property that ensures that you're going to return. And it helps to actually maintain the presumption of innocence because it ensures that you have the chance to be not incarcerated while you wait your trial. Bail is not guaranteed. If bail is used, it can't be excessive, but it's not guaranteed that you're going to get it. If you're a danger to your community and things like that, then it's absolutely reasonable for a judge to not give bail. However, if they do decide to give bail, then the amount needs to be reasonable. Then your book does kind of go a little bit through a timeline of cases dealing with bail. But I would like to focus primarily on cruel and unusual punishment the rest of our time. So cruel and unusual, what does that mean is an important starting point. It really depends on society. So this is one reason why what's cruel and unusual has changed. For instance, methods of execution have shifted over time. Firing squad and hanging used to be very common, and now no states permit a hanging, and only one state still has authorized the use of a firing squad as a method of execution, because what society considers to be cruel and unusual has changed over time. A really important case was Coker v. Georgia in 1977. We had the Supreme Court say that Coker's death sentence was disproportionate to his crime. So we had this in the 70s. We have the Supreme Court taking multiple death penalty cases, and for a couple years they placed a moratorium on the death penalty. They found that it was not being used fairly. It was being used very arbitrary or random fashion, and that's not what the Constitution demands. So when we're trying to decide what is cruel and unusual, we look at, does the punishment shock the conscience of a civilized society? Or are punishments super extreme? Like, for instance, another common punishment that we kind of inherited from England was drawing and quartering. They used to tie people, like each limb to a different horse or cart, and then they would each go their own separate way until somebody was actually torn apart. That shocks our conscience today. That would not be acceptable. We look at whether the punishment is unnecessarily cruel. This is one reason why hangings or drownings would never be an acceptable method of execution. Those are unnecessarily cruel, particularly given that we have an option that, while not perfect and may even not be very pain-free, but is more in line with our societal standards today in lethal injections. So, and then whether the punishment goes beyond legitimate penal aims. So these are the theories of punishment, why we punishment. Furthermore, punishments must be proportional or directly related to crimes committed. As far as proportionality, is the punishment proportionate to the crime? We look at the gravity of the offense. This sentence is imposed on other similar offenders in the same jurisdiction, and the sentence is imposed for committing this crime in other jurisdictions. So, for instance, when you read Roper v. Simmons, which is the case where the Supreme Court banned the executions of minors, you see one of the points that Justice Kennedy, who wrote that opinion, makes is that most states in the country don't execute minors anymore, or they even while it's on the books, it hasn't actually been done since the late 1970s, early 1980s primarily. Therefore, this punishment is cruel and unusual. So now the Eighth Amendment does apply to cruel and unusual punishment, does apply to more than just the death penalty. For instance, 3-strike laws have been reviewed under the death penalty, and those have been found to be constitutional in Ewing v. California. In Graham v. Florida, we had the issue of whether it was unconstitutional to sentence a juvenile to life in prison without the possibility of parole for a non-homicide crime. I'm pretty sure it was a robbery that Graham had committed, and the Supreme Court said yes. If the youth did not commit a homicide or intend to kill someone, then a life in prison without the possibility of parole is cruel and unusual. Now we have that has shifted even further, where all juvenile offenders, as Miller v. Alabama, need to have an option for parole. Just recognizing with brain development and all these other issues, it's cruel and unusual to sentence a juvenile to a life term without the possibility of parole. Now, again, that doesn't mean the juvenile will be getting parole. It just means that the possibility of parole still needs to be on the table. Now, after Furman v. Georgia, I said a little bit earlier in this video that there was a moratorium on death penalties. That came after Furman, and it suspended executions across the country. So we see states revise their death penalty laws, and it goes back in front of the Supreme Court eventually. And we see that bifurcated trials were introduced. So these are two-step trial process for death penalty cases. The first phase is guilt or innocence, and the second phase is whether or not the death penalty will be imposed. So that was introduced. Now, we do have a series of exclusions, groups that are categorically excluded from receiving the death penalty, one of which is juveniles. We've talked a little bit about that already. So juveniles cannot be executed under the evolving standards of decency. Other groups that cannot be executed, this terminology is dated. This is what the Supreme Court writes about, and if you read the full case, this is how they talk about it. But the new term, the appropriate term, is an intellectual disability. So someone who has an intellectual disability cannot be executed. Now Atkins only applies to those intellectual disabilities and does not apply to other conditions. Now, the mentally ill cannot be executed if they are mentally ill. So Ford v. Wainwright, Ford became mentally ill while he was in prison. He developed paranoid schizophrenia. He thought he could control the governor with brainwaves. And a lot of different delusions that he was under. And the Supreme Court ruled he cannot be executed. Now this is similar to Atkins but different. And additionally, you can, for instance, have an inmate take medicine and become sane and then execute them in most places. So this is not as strong of a protection as this slide makes it sound. People with mental illness are still executed. It's just those who are legally insane, which is a different standard than mental illness. Now, the rest of this chapter deals with kind of the Eighth Amendment and corrections. There's individual institutional conditions and corrections, as well as actions against individual prisoners. These types of cases often look at solitary confinement, corporal punishment, physical abuse, force, treatment, and the death penalty. The Supreme Court has been called on to determine multiple different conditions, like double cells are not cruel and unusual on their own. Now, if we had like 5 people or maybe something like that, then it could be, but just having a crowded cell is not in and of itself a problem. Prisoners additionally have to prove that the conditions, so the burden, this is telling us, Wilson is telling us the burden rests on the prisoners, not on the institution here. So the Eighth Amendment deals a lot with these ideas of due process and what is cruel and unusual. And there's a lot here. I'm going to take a quick pause and pull up a couple. All right, so we're back here, and I wanted to take a minute to walk you through Miller v. Alabama because I referenced that earlier in this video. One thing I'd like to point out for you is Brian Stevenson, who wrote Just Mercy, is one of the attorneys here. And so this is, the FOIA is really nice because it lays out the facts of the case as well as all the different opinions. So Miller committed homicide, and he was sentenced to life in prison without possibility of parole. He was 14, and so he challenged this with the thought of whether or not this in and of itself violated cruel and unusual punishment. And we have the Supreme Court writing yes. It is cruel and unusual to have a mandatory sentence of life in parole without the possibility, even for a juvenile homicide offender. Justice Kagan wrote that children are just constitutionally different from adults, and this is an unconstitutionally disproportionate punishment for a child. So I just wanted to bring that up. Now, another more recent case is Madison v. Alabama, and again, we'll point out here that Brian Stevenson was the lawyer for Vernon Madison. Vernon Madison was on death row for over 30 years. The average time on death row is between 10 and 15 years. So he's been there, double or longer than the average offender, in part because he had multiple trials that were thrown out on the basis of racial discrimination. Along with that, while he is in prison, he has a series of strokes and he's unable to remember the crime itself. When told he is argumentative and he says he didn't do that. And so this case went before the Supreme Court. And is it constitutional to execute a prisoner who has a mental disability that leaves them with no memory of an offense? And is it cruel and unusual to execute a prisoner with a severe cognitive dysfunction such that he cannot remember the crime for which he was convicted or understand the circumstances of his execution? We have on the Supreme Court finding that it is acceptable to remember a prisoner who does not remember committing his crime. But we cannot execute someone who does not rationally understand the reason for his execution, whether that comes from psychosis, or something similar to insanity, or whether that is the result of dementia. So this is another more recent case that just kind of provides some clarity about who and how we can execute someone. So if you have any questions about the material, please let me know.